Welcome to the Family Law Channel. Newly elected and sworn in San Francisco Sheriff Ross Mercury is under investigation for alleged domestic violence, an incident that happened over New Year's Eve. What are the potential conflicts of interest here, and what are the repercussions for the sheriff? The only person I can think of who can answer this is the host of the Family Law Channel, Judge Eugene Hyman. Welcome back, Judge.
Thank you, and Happy New Year to you and to your listeners.
Same to you, Judge Hyman. So Ross is elected. This happened after he was elected and before he was sworn in. And talk about the potential conflicts of interest with the district attorney who works very closely with him normally.
Right, and the first issue to discuss is I'm not so sure that there's an actual conflict of interest for anyone. The concern that I would have if I were the elected official, and please remember that the district attorney of any county in California, and I suspect in any county in the United States, is an elected position. So he's elected and the sheriff is elected, and they're looking probably for many of the same supporters and probably have been endorsed by many of the same people. So it's a perception issue as compared to an actual conflict issue. So in terms of perception, you have the situation, and I don't know if the district attorney, Mr. Gascon, actually endorsed anyone for the office of sheriff. My best recollection is that he didn't. Obviously, if he did endorse someone, whether it be the person who was elected or a competitor, then that would make it more of a conflict. But the prosecutor of a county works extremely closely with law enforcement within the county. We're not talking about a deputy sheriff, we're talking about the sheriff. So I would think that would be awkward and might present a perception problem. If the district attorney were to declare a conflict of interest, and he makes that decision himself, it isn't like if you have to make a court decision. He declares a conflict, and it automatically, by operation of law, goes to the Attorney General's office. And interestingly enough, Ms. Harris, who was the former district attorney in San Francisco, endorsed a different candidate for sheriff. So potentially, I imagine the sheriff would be unhappy if the Attorney General were involved, since she didn't endorse him. But on the other hand, if I were the district attorney, and I'm not saying that if he decides not to recuse himself, it's an ethical decision that he has to decide for himself in terms of what does he think how the public is going to react to that. So that's the first issue, has to do with the prosecutor.
And let's talk about what happens if, for example, so he's just elected and he gets convicted. Now,
right.
your assessment here is that if he is convicted, this would probably be considered a misdemeanor and not a felony. And if it was a felony, well, he can't really be sheriff anymore, right?
Well, by operation of law, if you are a constitutional or an elected office holder, which he is under, he holds an elected office. By operation of law, if you have suffered a felony, you are excluded. Now, if a judge were to suffer certain convictions, even as misdemeanors, he or she would be removed by operation of law. For example, fixing tickets, which has happened, that would remove you. Being convicted of a crime of moral turpitude, petty theft, for example, domestic violence by case law is a crime of moral turpitude. That doesn't automatically, for a misdemeanor, remove you from elected office. It does, however, subject you to impeachment should you testify in any kind of a proceeding, because it's a crime of moral turpitude. But that in and of itself doesn't remove you from office. But the awkwardness here, the Constitution lays out what the qualifications are for a sheriff, and basically you just have to be over the age of 21. You don't have to have a law degree or anything like that. You do for Attorney General, but not for sheriff. In other words, a sheriff doesn't have to be able to possess a gun, interestingly enough, or a firearm. all of the other badge-holding, possessing members of his office have to be able to do that. Probably also have to have driver's licenses. He doesn't even require to have a driver's license. But I think it would be very awkward for him to continue in the court of public opinion if he were to suffer a conviction which would, by operation of law, prohibit him from having possession of a firearm. Under California law, it's 10 years. A judge could make a finding that he needed it for his employment and excuse the disablement. However, under federal law, which passed a number of years ago, he would be disqualified from owning any firearm for life. Now, here he's the sheriff, and he can actually give gun permits to the extent that he does, but yet he wouldn't be able to possess a gun himself. I think it makes it very difficult for him to continue in office should he, in fact, be prosecuted and be convicted of a crime of domestic violence for that reason.
Well, as always, you have assessed and dissected the story like a sushi chef, Judge Hyman. We appreciate your time. Thanks for joining us today.
Thank you.
This is the Family Law Channel. I'm Scott Drake. Thank you for watching.